Hey y'all, it's Ducky. I hope everybody is having a great Easter if you celebrate Easter. So, we have gone over the motions in the state of Arizona bar versus David Gingras. We have gone over both of those. And then we went over most of his blog posts that I missed, like in the last 2 weeks. And then, of course, he posted and then he posted another one, said he was going to quit. Then he decided that he wasn't going to quit because he can't quit. He won't stop. Can't stop, won't stop. And so I'm not really going to go over much of that. But I do find it interesting that he talks about, he just talks about, lying is not okay. And he hates liars and says it has suddenly become okay to pretend the law isn't the law and the facts aren't the facts. And lying has become a presidentially authorized sport, which, because he has to make everything politics. And when politics is your whole personality, it's just not for me. You can be into politics, but when it's your whole personality, um, it's just meh for me. Um, and then he brings up like hand-sized fetuses, and yeah, that was a lie. Well, it's not a lie. Maybe she didn't say they were hand-sized, but the fact that she is supposedly holding them in her hand in the picture that she did, that would be considered hand size. So no, not a lie. It's just he's not quoting what she said. Woodenich is putting in there that she passed fetuses, and in the picture, they look to be about hand size. But, he has, in today's thumbnail, his Easter best hat on with his tinfoil conspiracy theories and speculation. But he says he cares so much about the truth and he doesn't condone anyone lying ever, which is really rich coming from him because you supposedly hate lying so much, but you represent one of the biggest liars there is out there. And you tolerate her just fine and think she's just a lovely person that's misunderstood. And so, the world is out to get him and Laura and all that they do. And so, it's just nothing. And it's the audacity and the hypocrisy to say some of the things that he says it is insane in itself. I just don't see how he can just sit there and say all this stuff knowing who his client is. And that if he is repeating what his client is saying, it's lies. He doesn't like it when we read other people's motions because he says that when we read their motions, they're lies about him and they're lies about Laura. But reading your stuff, there are nothing but lies in there as well. Yeah, he lied when he said he dropped her if she ever lied. That was a lie, Gingras. The lie detector determined that's a lie. I'm gonna have to go listen to Felony Flames. I've probably heard it before. I am not putting it to memory. So I'm gonna have to go find that of Megan Fox's. But we have the what's this? Mm, mm, mm. I don't want that. Where did it go? Stage motion. I don't want a reply. Okay. I'm trying to think. Did we go over? It's only 9 pages. We'll go over it. I don't remember if we went over this before, but we'll go over it again if we have. If the truth sets you free, what do lies do? According to Gingras, they are soul destroying and let's see. And pulling the truth from the jaws of dishonesty takes a lot of work. But he still has faith that the truth will eventually come out. But man, it's soul destroying to see the lengths people will go to try to ensure that doesn't happen. Yeah, it is really hard to get your client to say the truth. And it is soul destroying to see the lengths at which your client went to ensure she ruined all these good people's lives so that the truth doesn't come out. And you are a part of that. Because what they haven't done, and if you watch or not watch, but if you listened to the Love Trapped podcast, it was talking about her sonogram and Planned Parenthood and all of that stuff. Oh, that stinks. That stinks that you don't have power. Um, but they talk about, this Los Angeles thing comes up. And what they haven't done since the trial is shown proof about Los Angeles. They have not corrected the record about Los Angeles. None of it. There has been no candor to the court about what has been learned about Los Angeles. And it's a lie. Oh, I made deviled eggs today. Weather here, at least in DFW area, has been okay. It was a little chilly yesterday with the wind. But I don't know if it's bad about Yeah, that's what I'm talking about, LA, is the Planned Parenthood in LA, that they've done nothing to correct the record about Planned Parenthood LA. They they've they've not addressed it in public, they've not addressed it in a blog, nothing. There's been no correction of the record of the truth about Planned Parenthood, and no correction or proof about LA. And her excuse about, "Well, I thought I had privacy." And it's like, yeah, you do have privacy from people getting those. But the problem is when you try to go to court and you are supposed to be proving something, that privacy is done with. Like, you're here to prove that somebody fathered a child, but you're not willing to provide any proof about that. And it's because you don't have any. And your pee sticks that possibly came allegedly from HCG injections, um, that's not proof. That's proof that you injected yourself with ordered HCG injections that came to your casita. But you still provide the medical evidence because it is so easy to prove. And the fact that you don't want to prove any of it. Because had you have just given up your privacy for, you wouldn't be in this situation. If what you were saying was true, you wouldn't know money. You wouldn't be under criminal indictment. But you're here saying that you went to these places and had a sonogram of your stomach with twins in it, but you're not willing to show that medical record to anybody because it doesn't exist. And you're willing to possibly go to jail for it. You're willing to have a balance that you owe from appeals courts and Judge Mata's. Like, give your privacy up, woman. But you're not. It doesn't exist because no person acts like this. No person is like, yeah, I'll just file for bankruptcy. But you know what? My privacy is, important to me. It's not believable. It's a lie. And nobody's going to buy that shit for a second. And her clock is ticking on her plea deal. We are now in April. So, and from the looks of it, what her attorney just filed, it doesn't look like she is going to be taking the plea, which I think is weird. Um, I still would love to. I had questions and I really was hoping MG Law would answer them. About the newest things for Gingras, or not Gingras, for the Laura Owens stuff. And so I'm wondering, would it be in notifications? It's not notifications, that's something else. Okay, so I tagged MG Law last week, and in the filings for Laura Owens' trial, there was a motion to extend time for filing a motion, and I believe that was granted. because he wants to redetermine probable cause. And I don't that was one of them. Redetermine probable cause. And then what was the other one? But what I asked was, and that he wants it remanded. So my question is, where would they remand this to? Because they're saying it's possibly not like in the right venue. Also, if everything was done correctly in the grand jury and they have all the evidence that they do, because we know there is a mountain of evidence in this one, an actual mountain of evidence in this one against Laura Owens. I don't know how they're going to get a redetermination of probable cause because she wasn't indicted on probable cause. She had grand jury indictments. And so that is my question is where would they get remanded to? And I don't know how she's going to get a redetermination on probable cause. And I haven't, if MG Law has gone over it, I haven't seen it. And so I really want the answers to those questions on those filings because I am not understanding any of that. It doesn't make sense to me. And so there must be something I'm missing. I know he needs more time to look through all the paperwork. And he hasn't filed for the remand yet. But if even when he looks through it, I don't well, he can keep the option open for to be remanded. I don't think it's gonna make a difference. So no, no, no. In order to go to the grand jury, you are present. Yes, I mean, you are to the grand jury. I guess so. Um, it's slightly different, but you're presenting probable cause. Jury determines PC. He missed the deadline to argue about grand jury because he just got appointed. Okay. But I was looking up that usually if it's a grand jury indictment or probable cause, unless something went horribly wrong in that grand jury, like there was actually like they lied about evidence, um, or there was something weird happening, then it is it is really hard to get that probable cause changed. And it's just I mean, he can try. He can try every avenue he wants. I mean, that would be zealously advocating. Um, but if he thinks that he's gonna get this grand jury thing, unless the prosecution or this in this like the state messed up, it's not happening. Yeah, unless there's prosecutorial misconduct, which if you have followed anything that's going on in Massachusetts in the Turtle Boy, you will have known that Mark Bedrow passed or like wrote this long thing about all the shit that was prosecutorial misconduct in getting an indictment against Turtle Boy. And that was crazy. And that didn't happen. So if all of that shit happened and it didn't go anywhere, I don't think it's going to go anywhere here. Yeah, there has to be something crazy wrong. And I was wondering if, because they were talking about that, what is it, 270 days or something like that? Yes, that was Massachusetts. This is Arizona. I know that, but I'm saying it would have to be something like what was happening in Massachusetts or worse to have happened when, Maricopa County took this to a grand jury. And I mean, if there is, then okay. But I'm thinking it's probably not happening because there just is so much here. Oh, Massachusetts is so horrible. Um, but there are things that have gone wrong in Arizona too. But this is not the case. There's no need to try to twist and manipulate anything about the case against Laura because she has done all the manipulating and twisting that we need to indict this woman. And you're either pregnant or you're not. And you weren't. So that was just something. And then I was shocked that I was wondering if her case could get moved because a lot of cases do get moved. They can go further and they get rescheduled and rescheduled and rescheduled, like the Courtney Clenny case. It's like, okay, we're fixing to go to trial. We're going to start trial. And then they're like, yeah, no, we're not going to start trial. We're moving it once again. So that, I didn't know if that was going to happen because they seem to be so strict with this 270-day thing that she needed to be done and in trial and all that by like the end of July, beginning of August. And so I didn't know how much of an extension and stuff. Yeah. And so that 270 days is that. So I'm wondering with all these new attorneys, and if this attorney stays on till trial, great. But if another attorney gets moved on, like, how are they going to have this go to trial within this 270 days? Because Laura is the type of person, kind of like Sarah Boone, that's just going to want to continue to extend and extend and extend the inevitable. So if this jury or this lawyer is maybe remand the grand jury transcripts back, not remand the case. Did write in a motion when he took over that he was ready to go for trial. That is true. He did say he was going to be ready to go to trial. So I'm hoping it's just remanding the transcripts and not the case. But when it said for probable cause, that's where it confused me. Yeah, and there were 2 grand juries. It wasn't just one. So it is, and if they don't hold that time frame, does that go into Laura's appellate rights and certain things like that? And it's just something I would like to know from a lawyer because those are questions I had when I saw those documents this past week. But yeah, that's good. That all the party like discovery. There's no reason anybody should be holding discovery. The only one that would be holding discovery would be Laura, not wanting to hand over things. But I think the state, because they have, resources, they don't need her to hand over shit. Um, so they are going to, um, oh, okay. I like green. You're a retired prosecutor. All right. Yeah, she's not gonna want another grand jury. Mm-mm. There's just well, I'm glad you have your power back, Texas. But there's stuff that she could have, but I think the state has whatever they need, and so they're like, "Okay, we're ready." Like, we're ready to go, and Laura's the one that's like, "But wait, but she, she wants to delay because she wants to delay the inevitable. We know the shit she likes to pull when the clock is running down." So, she always likes to pull something. Oh, yeah, and they're gonna possibly be homeless, which I don't know where they're gonna be living because that casita, it's just, and none of this had to happen, you know? None of what they're going through had to happen. And while Jan and Ron have a lot of fault and stuff, and them enabling their daughter to be the way she is and funding the way she is, it's just, you know, I don't know what delaying the inevitable. It's because she's out free right now. But she has a way to stay out free, and that's to take the plea deal. As much as I would love to see it, and she's not gonna testify. Like, if she doesn't have to testify and get cross-examined, she will not be taking the stand. She's not one that we're like, "Will she testify?" Like, wondering if, like, Corey Richens or Donna Adelson or any of them were gonna get up there and talk. Um, she's not gonna be like Alex Murdaugh getting up there on the stand because she doesn't like being questioned. It would go horrible for her. And so I don't know if they're going to have much of a defense or if her defense is going to be the state didn't prove their case. Like in Corey Richens, we don't think the state proved their case. Lori Vallow, same thing. We don't think the state proved their case. And then closing arguments. 'Cause unless they have Med Chill come and testify, which that's okay. It's, you better hope there's no mothers on that jury or anybody that knows about babies and how they work and pregnancies. This is going to be really hard. So let's go into this motion for partial judgment on the pleadings in the David Gingras matter against the bar. So let's pull that up. Lord. Yeah, anybody that has any attachment is going to be a witness. It's whether, because you want to make sure that you put anybody that they could call on your witness list, because there's a chance that they might not put them on their witness list, and then you're like, "Oh shit." So you put all the people that could possibly be a witness in your case. That doesn't mean you're going to use all of them or half of them, but I mean, they could get probably every officer of the Scottsdale Police Department in there talking about her, because I'm sure every single one of them has at least had one encounter. Well, it's, the pregnancy scheme thing, MedChill could be a witness for. Saying, he could be an expert witness talking about, "Oh, yes, you can be pregnant, dribble before you shoot pregnancy," and his Christmas Maria virgin story that he has. So he wouldn't he would be it would be stupid, but he could just be their expert pregnancy person. But maybe her lawyer thinks that dude is a quack too, so who knows? Thus far, her new criminal lawyer is doing everything he should, and so that is I mean, that's what we want for her. Because if you've seen, like, before Brian Koberger, took pled guilty, and now it looks like Rex Heuermann, from the Gilgo Beach murders, is going to be pleading guilty, and it's because, one, they did it, but their defense team tried everything that they could do to zealously advocate for them by trying to get certain witnesses thrown out, by getting certain evidence thrown out, by filing every motion you could possibly file. And if none of it succeeds, there's nothing else that you can really do in cases like that. And it's like, okay, so all the witnesses that are going to say all this stuff are going to testify. And all this evidence that we know doesn't look good for you is going to be coming in. So at the end of the day, you just need to plea. And so this lawyer could be trying everything, being like, you can be guilty, but I'm going to try every motion and try to get the best thing for you. But at the end of the day, it may just be you're just guilty. And I tried everything. I tried every defense mechanism that there is for you. And sometimes you're just fucked. We might go back and look at those to see. He m The only thing I could see him the only one I can see him testifying about is being an expert in, like, pregnancy and prenatal stuff and testifying about how all that stuff can work to try to be a defense that she thought she was pregnant and that she was pregnant. I think it would be a shitty witness to put on as a defense thing because if you have everything I mean, but they could try to just throw spaghetti at the wall and be like, "Well, yeah, after MedShield testified, I now believe there's a possibility she could have believed and thought she was actually pregnant." It's not gonna work. Well, she's blaming Clayton for her bankruptcy problem too. She was like, "But Clayton knows the answer." Well, Clayton's not a party to your bankruptcy case, ma'am. I mean, he's an adversary, but Clayton knows that it was a money investor and I didn't really have the money. Ma'am, Clayton is not a party to this right now. I am Queen Jennifer and you're the one that made a statement. Has nothing to do with whether Clayton knew this or not. But she likes to put up defenses that have nothing to do with the topic at hand, much like her attorney. Talks about things that are not relevant. So stupid. But Clayton knew. So stupid. So stupid. Okay. Also, hit that like button, subscribe, turn your notification bells on. And let's get into this finally. Sorry for the people that don't like when people do a bunch of other stuff prior to. We are just here. All right. So, filed on March 9th, 2026, before the presiding disciplinary judge. Motion for partial judgment on the pleadings in state bar case. So, Yeah, but Clayton has nothing to do with her claiming it's her money 1 minute and not her money the next minute. But in her mind, because Clayton knew, the bankruptcy court should just know that what she was saying was true or false, or what was in the affidavit. And it's like, yeah, but you're just supposed to put down things that are true. And how is the bankruptcy person supposed to know? Why does the bankruptcy person care if Clayton knows or doesn't know what she put in her thing? The bankruptcy court is there to determine what is real and what is not in this particular case. And Greg, he's just the hacks into all the stuff. So, I mean, maybe he went in and changed her affidavit, his hacking that he does. Kidding. We know Greg doesn't do that. No, she gets so offensive. Okay. Pursuant to Arizona Rules of Civil Procedure 12C, incorporated into disciplinary proceedings by the Arizona Rules Superior Court or Supreme Court 48B. The State Bar of Arizona moves for a judgment on the pleadings regarding several ethic violations alleged in the State Bar's amended complaint because respondent's admitted answer has admitted sufficient facts to support the alleged violations. Yep. Because just because he has a defense for him and he thinks that they are justified, it doesn't mean that it's actually ethical. Legal basis. Regarding a motion for judgment on the pleadings, the court may consider as truth such allegations of complaint as are admitted by the answer. If these allegations set forth a claim for relief, the answer fails to assert a legally sufficient defense, plaintiff is entitled to judgment, citing some case law. Factual basis. On February 17th, 2026, the State Bar filed its complaint, which was served timely on respondent. Respondent filed his answer on February 19th, 2026. Yep, he filed it so fast, he did not have time to go read the transcripts when he could have just waited. But he just had to get a pecking on that typeboard. Following an initial case management conference, the State Bar filed an amended complaint on February 25th, 2026, to address formatting issues raised by the presiding disciplinary judge, PDJ. And the footnote says the amended complaint only differs from the initial complaint insofar as 2 medical records and 3 social media posts that were included in the initial complaint were removed from the body of the complaint and attached as exhibits because they do not want that stuff in the filing. They just need to be exhibits, which Gingras did the same thing. On March 9th, 2026, respondent filed his amended answer, which respondent identifies as substantially identical to the answer respondent filed in this matter on February 19th, 2026. The only difference is the deletion of images from the filing. Respondent has unequivocally admitted most of the facts, which, as explained more fully below, independently establish certain ethical violations set forth in the complaint. See amended answers at paragraphs, and they list all the paragraphs. And we went over those that he admitted. While respondent partially admitted other paragraphs, the qualified admissions substantially admit that the alleged facts necessary to support the alleged ethical violations. See these paragraphs. Finally, respondent denies certain allegations that are not necessary to prove the alleged ethical violation. Those paragraphs. Respondent violated Judge Mata's February 21st, 2024 order in violation of Rule 42, ER 3.4C, 3.6A, 4.4A, and Rule 54C. Respondent judicially and unequivocally admits the following paragraphs, which independently prove respondent's violation of Rule 42 and all the other rules that we read just a minute ago. Paragraph 9. Respondent admits that Maricopa County Superior Court case in the matter of Owens and Eckerd was filed on August 1st, 2023, hereinafter referred to as paternity case. Yes, he did admit to that. The respondent also admitted that he was hired by Laura Owens in March of 2024 and filed a notice of appearance in the paternity case on her behalf on March 25th, 2024. Yeah, because it was right there around Easter weekend, I believe. Yeah, it was like Easter weekend. Respondent admits that he knew of Judge Mata's February 21st, 2024 in the paternity case, stating, among other things, that no party shall disclose outside of themselves any medical or other documentation, exhibits, medical records, etc., disclosed between the parties. Respondent also admits that he subsequently filed a motion in the paternity case attaching a declaration dated April 1st, 2024, which was signed by him and included 3 medical records. Paragraph 44, respondent admitted that in his April 1st, 2024 declaration included references to 3 medical reports or records, which was attached to the motion. He admitted that he posted a Sonora Quest Lab medical record dated October 16, 2023 on his law office blog on April 4th, 2024, which was a week ago or a year ago, 2 years ago yesterday. Ugh, we've been dealing with him for 2 years. Respondent admits that he was immediately informed of the violation of Judge Mata's February 21st, 2024 order. He admits that he subsequently posted a portion of another medical report on his law office blog. He admits to filing a responsive document in the paternity case on April 26, 2024, which included medical records and summary portions of expert medical reports, which were prepared for the opposing party. Respondent admits that he posted the April 26, 2024 response, as well as attached medical information and documents on his publicly accessible online X, formerly Twitter, account, his law firm's website and or other social media on April 27, 2024. While respondent denies the conclusion that he violated the cited ethical rules, based on the foregoing, respondent admits the essential factual allegations supporting a finding that respondent violated Rule 42 and all the rules that we've cited, that respondent's disparaging comments about Judge Mata were violated. Respondent admits the following paragraphs, which independently evidence respondent's violations of those rules. In paragraphs listed, respondent admits making the cited statement regarding Judge Mata and the public, the contents of which speak for themselves, quote unquote. In his defense, respondent affirmatively alleges that he believes or believed in the truth of the disparaging statements and believes that the disparaging statements constitute an opinion protected by the First Amendment of the United States Constitution and by the Arizona Constitution, not Arizona. Respondent's belief is disproven by, among other cases, the following specific to attorney discipline, which is what Patrick and Omar have been stating, basically, that this trying to make it a First Amendment thing was just not going to work well for him. Oh, I don't think Dingus has sobered up and realized mistakes. So it cites a bunch of cases for that because he's saying, oh, it's First Amendment as an attorney. While respondent unequivocally admits making unprofessional and disparaging remarks about Judge Mata, and he still continues to while he's facing this, respondent again denies the conclusion that he violated the cited ethical rules. However, Based on the foregoing, respondent admits the essential factual allegations supporting a finding that respondent violated the rules of the ethics, Conclusion. For the reasons set forth above, PDJ should enter a partial judgment on the pleadings under Arizona Rules of Civil Procedure 12C in favor of the state bar and against respondent on the unequivocal admitted facts which prove the alleged ethical violations and set this matter for an aggravated mitigation hearing to determine the appropriate sanction. State Bar, Craig D. Hinley and James Jim Lee. And so I wonder, let me see here. Let's go. So one of the cases the state bar posted. Let's see. Conclusions are probably time. I may have to look at these at another time. Let me see. Summary. I was wanting summaries on these, but let's see, occurred when he was this. Was guilty of made ex parte communications. He made unfair comments on a decision by a judge. So that was the first one, the James Lawrence Riley. Let's see on this one. You're just not allowed to be making these types of comments as a bar person. Oh, Gingras is apparently... Oh, we'll get to hear about these at a different time. I'm guessing because it's in reply. So we are going to... All right, let's switch to Gingras's reply to this. So we are going to share this tab instead. Yeah, he is a bar person. Yeah, he's a bar person in more ways than one, as Texas Packet says. Yes, Gingras has the First Amendment rights. He can go put whatever he wants on his blog. If the bar decides to fire him for that, that's his problem, not the First Amendment's. It's just that it would be against the law if he was being jailed like, it would be a problem if Gingras was being jailed for it. I've gone over. But there are consequences. You're just not going to go to jail for it and lose your liberty and freedom over it. You can, however, be fired and lose your memberships and certifications and all of that. Like, it's not free from consequences. So here we have on March 23rd, 2026, Gingras replies to the state bar's motion for pleadings on, or judgment on the pleadings. So here he goes on. The State Bar of Arizona, by undersigned Bar Counsel, submits this reply to the State Bar's motion for judgment on the pleadings. Introduction. A respondent's motion contains significant information woefully irrelevant to attorney discipline cases. Arizona attorney discipline cases are, let me see what this means. We're going to learn a new word, guys. A Latin word. Sui generis. Which it stands in a class alone. It's in law, it's a term of art used to identify a legal classification that exists independently of other categorizations, either because of the singularity or due to the specific creation of an entitlement or obligation. For example, a court's contempt powers arise sui generis and not from statute or rule. So he's saying that the bar's complaints are just, they're not out of the fact or the rule. They're just on their own. They're unique. It's so weird. They're not based on a statute or a rule. They're just, I guess, vibes. I don't know why. Okay. The proceedings are expedited and therefore by necessity limited to issues relevant to the allegations of attorney misconduct. And he cites a rule. The pending motion identifies the pertinent admission, factual allegations, and seeks findings for the related ethical violations. See Arizona 12C, Arizona Rules of Civil Procedure, specifically incorporated into attorney discipline proceedings pursuant to Rule 48B. As explained more fully below, respondent failed to offer any relevant legal basis to defend his actions and instead argues that he would rather continue litigating the dismissed underlying state court cases in this attorney discipline matter. Okay. Wait. Reply to state bar. Okay. Why does it not sound like Gingras is writing this? Factual basis remains undisputed. Respondent knew that his admitted conduct violated the rules. And then he cites things that requires a knowing mental state. States that knowing, known, or knows denotes actual knowledge of the fact in question and may be inferred from circumstances. Okay. Respondent's response offers no legal dispute. No legal dispute of that. Who wrote this? Hold on. Okay, that's why. This is not Gingras writing this. Okay, I'm sorry. This is the state. Reply to state. Yeah, he thinks that he is about free speech, and he's not. Okay, I have to go back because okay, respondent's response. $318. What is this one? Okay, no. I guess this still goes with the other thing. I am so that's motion for the partial judgment. I don't know what I was on a while ago. Okay, now okay. We're gonna reshare because I don't what the hell I was just reading. This is Gingras's response. Okay. 3/18/2026 is when this was filed. Response to state's motion for partial judgment on the pleadings. Okay. Introduction. In terms of the underlying facts, this case is exceptionally complex. It's actually not. You just want to make it that. And notice the thing was 9 pages, and this thing is 23 pages. Fortunately, the issues raised by State Bar's motions are relatively simple. The Bar claims it is entitled to a judgment on pleadings because no material facts are in dispute. And based on those undisputed facts, the Bar asserts it is entitled to judgment as a matter of law. Gingras says this argument fails for 3 separate independent reasons. First, contrary to the Bar's argument, multiple material facts are in dispute. That point, standing alone, requires the denial of the Bar's motion. Second, even if all material facts were undisputed, which they're not, he says, the Bar's position is directly contrary to controlling law. Accordingly, the Bar has not shown it is entitled to judgment as a matter of law. This leads to the third and perhaps most important point. The Bar has moved for judgment offensively, i.e., it seeks an order resolving several claims in the complaint. But in this posture, where a complaining party seeks judgment on the pleadings offensively, the court cannot limit its review to only the complaint. Okay, so they can consider your response as well. They would be considering the complaint and your response to the complaint. So it would be Jim's allegations, basically, and then your answers to those allegations. And in reading those, the judge could come to a determination on some of those counts or charges or whatever they're called. Rather, in addition to reviewing the complaint, the court must also consider defenses raised in respondent's answer. Well, the thing is you admitted you wrote those things and that you posted those things. So the thing is whether you have defenses for them or not, if you are not allowed to post those things or write those things and act a certain way, then it doesn't matter why you did it. You weren't supposed to do it. So you admit, yes, I wrote those things about the judge. Well, if you're not supposed to write the things about the judge, it doesn't matter whether you have a defense for writing it. If you are not supposed to post the medical records publicly and only supposed to disclose them to the parties, no matter what your reasoning is for it, you violated an order. And so the judge, on your answers and on the complaint, can decide that no matter why you say you did it, you weren't supposed to do it. So you can be found to be guilty of violating ethical violations, if that makes sense. Yeah, he's proud of it. He's got his tinfoil hat on and thinks all of this shit. It just like he just makes his thinking it hurts my brain. And maybe we're the ones that need tinfoil hats to protect our brains from all that nonsense. Like maybe the tinfoil hat is to protect our brain from becoming warped like them. Because we need to protect our brains from becoming this obtuse. So he says, assume every fact alleged in position taken in respondent's answer is true. Yeah, we can do that. We can say that everything that you supposedly said was true. But if it is unethical and against the rules of being a lawyer, even with your defenses, it's not going to go in your favor, Gingras. Apply all reasonable inferences in favor of respondent. What is favorable to you in these things? None of your defenses are favorable. So taking all of the facts as true, the court must consider whether as a matter of law the answer raises any potential defense to the bar's claims. If the answer shows any potential viable defense, this court's task ends. In that case, only one choice remains. The court must deny the bar's motion so the record can be fully developed. The thing is just because you have a defense doesn't mean it's a good defense. Sometimes people's defenses don't matter. Even if somebody was like, yeah, I killed that person because they were a horrible human. That's a defense. It's just not going to be a good one, and you're going to go down for it. But you like vigilante. So I'm sure you're like, but it's justified. And it's like, it doesn't matter if it has a justification, if it's still illegal. So, okay. Let's see. The court must deny the bar's motion so that the record can be fully developed. Only then may the court review the facts, determine whether they are uncontested, and if they are, the court may consider whether one party or the other prevails as a matter of law. The thing is you put some facts in the thing when you were just supposed to admit or deny. That's it. That task cannot be done on a bare, undeveloped record based solely on the pleadings. It wasn't well, okay. If he's going for literal language here, which I think is what Gingras is doing, is he is saying that they cannot just take Jim's complaint by itself and just think that everything is true. They have to take Gingras's answers as well. And so maybe Jim didn't need maybe I think he's being technical here, and maybe Jim should have filed a different thing that doesn't say on the pleadings, but I think it is just on the pleadings and the admissions. I don't know what else you would have called it, but technically, yeah, you don't just take it from Jim's pleadings only. You take it from Jim's pleadings and Dingus's answers, which is what Jim means. And I'm pretty sure the judge in control of this disciplinary who's going to be hearing this motion about the pleadings understands that it would be Jim's complaint and Douche Canoe's reply. So I don't know if he's like, it can't just be on Jim's pleadings. You have to take mine and Jim's stuff together. That's probably a no shit Sherlock type thing, but okay. It, background. The origin of this dispute is a family court case. And court case called Owens v. Eckerd, filed by petitioner Laura Owens against Clayton Eckerd. Most of the extensive background details and procedural history of Owens v. Eckerd are cataloged in the request for judicial notice submitted herewith. The details of Owens v. Eckerd are exceptionally complicated. They actually shouldn't be complicated because it should be, was she pregnant or not? Did she prove it or not? That's how this should have been. But the only reason it became complicated is because she lies and can't keep her facts straight. Otherwise, it's not a complicated matter. The case initially involved a simple paternity case, but it metastasized into something far more complicated. Yeah, because your client is a liar. Aside from the narrow issue of Miss Owens' pregnancy claims, which was simple and ultimately moot long before respondent appeared in the case included what amounted to a civil tort counterclaim by respondent Clayton Eckerd. In his counterclaim, Mr. Eckerd alleged Miss Owens faked multiple pregnancies with multiple men over a period of nearly 10 years, and that she had engaged in misconduct in a variety of relationships with 10 different men. Or with multiple different men, sorry, not 10 different men. Multiple different men. This involved and or implicated extensive other litigation, including Owens v. Gillespie, Owens v. Eckerd, Eckerd v. Owens, Owens v. Maricini, Owens v. Mulvey, which is a non-existent California paternity case. What? Okay. Discussing the facts of each matter and explaining how they related to the paternity case filed by Miss Owens would take dozens and dozens, if not hundreds of pages. That was not fully what this case was about. It became about that because people discovered that you were lying here and that it wasn't your first time of lying. This is why respondents expressed incredulity at the state's bar's suggestion this case could be fully presented in a single day. That assertion was not an accurate reflection of how complicated this case is, as the PDJ is about to discover. It wasn't complicated. All Laura had to do was prove that she was pregnant. That's not complicated for anybody else other than her. But there is good news. To resolve the current motion, it is not necessary for the court to hear the entire story. Not yet. However, to help understand the background, which is necessary to resolve the bar's motion, some basic details of Owens are explained in respondent's declaration submitted herewith. Against that extremely complicated backdrop, after nearly 2 years of investigation, the state bar charged respondent with misconduct related to Owens. In the instant motion, the bar raises only 2 distinct claims: an allegation respondent violated a court order, which, according to the bar, required information to be filed under seal, and an allegation respondent violated multiple ethical rules by making disparaging statements about the trial judge, Julie Mata. As explained below, the bar is not entitled to a judgment on the pleadings as to either claim. The material facts relating to both claims are heavily disputed, and the bar's position as to both claims is directly contrary to law. Maybe she wishes it was 10 men. Maybe it's not contrary to law. Just maybe the way you read the law. Yes, tea time. The case is only complicated because Owens couldn't keep her story straight. So because it's sealed, the Mulvey case is sealed, and we can't see the contents, Gingras puts in his filing that it's non-existent. I know who Mulvey is. And I'm sorry I keep saying his name, but it's not a non-existent California case just because it's sealed. It's just, God, he's so dumb. In addition, respondents' answer, which the bar never discusses in any meaningful way, raises multiple viable defenses. What you think is viable is not necessarily. Those defenses preclude the bar's request for judgment as a matter of law, at least at this stage. Those defenses include, but are not limited to, an allegation the bar has misstated the law and omitted facts in the manner which presents a false impression about what occurred. Respondent also asserts the disparaging quote unquote comments he made about Judge Mata were entirely true. Not that he merely believed them to be true, and thus are protected by the speech under First Amendment. Your comments cannot be entirely true if you have no proof to back up your statements. It really is merely a belief that you think that is what happened, but you have nothing to make them entirely true. Respondent further asserts the bar seeks to enforce rules which are unconstitutional, and the bar has acted in an arbitrary and unlawful manner which violates respondents' rights under both the Due Process Clause and the Arizona Anti-SLAPP, ARS 1271 or 751. I cannot read today. Okay, so 12751 is the anti-SLAPP, which provides mechanisms for individuals to challenge legal claims that aim to deter or retaliate against the exercise of their constitutional rights, such as free speech. The statute allows a party to file a motion to dismiss if they believe the legal action is based on their lawful exercise of these rights. The law aims to protect individuals from frivolous lawsuits that could inhibit their participation in public discourse and civic engagement. I would like to know what lawyers have filed anti-SLAPPs and have won. They do defy logic. Under the highly deferential standards that apply here, the court is required to assume respondents' factual assertions and legal defenses are correct. The court must also resolve every reasonable inference in respondents' favor. Applying those well-worn standards, the bar's motion must be denied. Discussion. Rule 12C, legal standard. The court is familiar with the rules, but a short discussion is nevertheless helpful. When made defensively, a Rule 12C motion is subject to similar standard as a Rule 12B6 motion to dismiss for failure to state a claim. This standard requires that the allegations of the non-moving party be accepted as true, and that the allegations of the moving party which have been denied be treated as false. It further requires the facts be construed in the light most favorable to the non-moving party. Judgment on the pleadings is properly granted when there is no issue of material fact in dispute and the moving party is entitled to a judgment as a matter of law. But that's the thing. You admitted to the things, Gingras. So when you admit to something and Jim accused you of doing that thing and you're like, yep, that happened, then there is no dispute of the material fact. You admitted those things. And then he cites a case, which citing an extensive authority. Footnote 1, references to unpublished federal decisions are expressly authorized by the Arizona Supreme Court Rules 11.1 D, allowing decisions other than Arizona state cases to be cited as long as permitted by the rules of the other forum. The federal rules of the appellate procedure expressly permits citations to unpublished federal decisions. See Federal Rules of Appellate Procedure 32.1a. Unpublished state authority is cited for persuasive value per Supreme Court rule. Okay. Because the bar is acting as a plaintiff, there is a second step the court must consider, which the bar's motion completely ignores: whether respondent's answer raises any potential viable defenses. A plaintiff is entitled to a judgment on the pleadings only where the complaint sets forth a claim for relief and the answer fails to assert a legally sufficient defense. Well, I don't think your defenses are legally sufficient, Gingras. And I think that's what Jim is saying as well. Or stated differently, a plaintiff's motion for judgment on the pleading should be denied where issues of fact are properly raised by the answer. The court must accept respondents' assertions and defenses as true and construe all inferences in light most favorable to respondent. Under that simple standard, the bar's motion must be denied. B, the state bar is not entitled to judgment on the first claim accusing respondent of violating a court order. The material facts are disputed. The first issue involves a claim respondent violated a court order, which, according to the bar, required certain information to be filed under seal. The specific language at issue is found in a lengthy minute entry order issued February 21st, 2024, before respondent was involved in the case, which stated, "Let the record reflect, no party shall disclose outside of themselves any medical or other documentation, exhibits, medical records, etc., disclosed between the parties." Exactly. I don't think she has to say it needs to be filed under seal. The fact that you disclosed it outside of the parties is a violation. That's why you don't have a viable defense. On its face, this issue appears simple. Respondent answer admits the court issued the minute entry in question and admits the minute entry contains that language. However, that is not the end of the story. Respondent's answer affirmatively alleges the state bar has misrepresented the scope and meaning of that order by omitting extensive other information that conflicts with the bar's self-serving interpretation of that order. Answer at Respondent has further raised a defense that the bar's position seeks to punish respondent for violating court orders which were unconstitutionally vague and or which conflicted with other orders such that they failed to provide respondent with notice regarding the scope of prohibiting conduct. Answer at Gingras, but you could have gotten clarification. Then you were put on notice what it meant. And if you didn't agree with what it meant, then maybe you should have asked the judge. And so, but you just kept doing it over and over and over again. Like, it would be one thing if the first time you're like, my bad, I didn't realize that this is what it meant because she had said this in the past of things being sealed, that Laura couldn't have things sealed. And it was just like this whole case couldn't be sealed. But her medical records and things like that were going to be just shared between the parties. And it was just the medical records. And if it was just one time that you did something, that would be one thing. But the fact that you then published it on your blog, put it out on Twitter, and everything else. Yes, the minute order was denied to order to seal the entire case. But he's taking it as no, she said no, that Laura couldn't have this case sealed. So how am I supposed to take that when she says things can't be sealed? How am I supposed to know that medical stuff was supposed to be sealed? Because it contradicts what she said. No, it doesn't. You're being obtuse. And to me, you acting like you don't understand what that means is a lie. You're manipulating things. And I don't think your defenses are viable. So understanding those points require additional information far beyond pleadings. The reasons are explained in a lengthy respondent's declaration submitted here within. In short, prior to February 21st, 2024, minute entry, which respondent is accused of violating, Ms. Owens made no fewer than 3 separate requests for confidentiality, protective, and sealing orders, all of which were denied. The first motion was pro se, filed September 14, 2023. The court denied on October 20th, 2023. The second motion was filed January 17th, 2024 by Ms. Owens' prior counsel, which specifically asked the court to limit the sharing of information disclosed during discovery. She wanted the case sealed. Importantly, although Mr. Eckerd did not oppose Ms. Owens' initial confidentiality motion, which was still denied, his counsel, Mr. Woodnick, angrily objected to the second motion. The objection argued, among other things, it would be unconstitutional for the court to issue an order restricting the parties from sharing information about their claims. Yes, about their claims. But Laura, with her lies, saying that people were People were making her look bad, and so Laura wanted all of it to be a secret so people couldn't make her look bad anymore because they hurt her fifis and she thinks it's harassment. And she was accusing people of making things that they didn't make and lying about who actually had access to things and who didn't. So, Mr. Woodnick went further, arguing that because Miss Owens previously moved for an order sealing the case, which the court denied, it was improper for her to make a second such request. Apparently, petitioner feels she is entitled to what is essentially a backdoor motion to seal after this court already denied her attempt. And then he cites the, citation for all that. On February 15th, 2024, the trial judge issued an order agreeing with Woodnick's position. As a result, the court denied Miss Owens' second motion for confidentiality in its entirety. And that doesn't go. This led to a third request from Miss Owens via her prior counsel in the form of a verbal request for reconsideration on February 21st, 2024. That request was denied in the same order. The bar now respondent violated. It is further ordered denying counsel for petitioner's oral motion to reconsider regarding the ruling concerning petitioner's motion for confidentiality on the case. These facts show several things. First, long before respondent was involved in the case, Miss Owens made 3 separate requests asking, indeed begging, the court to limit any public sharing of information and or sealing public access to the court records. All 3 of those privacy requests were denied in their entirety, but sharing information and sharing medical records is different. Second, Mr. Eckerd's counsel Woodnick, why am I reading the same thing? Angrily challenged the request for privacy, arguing such a restriction would be illegal and unconstitutional. Am I reading? I don't know why I'm reading things twice. Okay, Woodnick, argued angrily, let the record reflect no party shall disclose outside of themselves. After that comment was included in the court's February 21st minute entry, Woodnick filed unsealed pleadings containing Miss Owens' medical records, information, and related documents disclosed between the parties. For instance, on March 11th, 2024, before a respondent appeared in the case, Woodnick filed a motion to compel. In the unsealed motion, Mr. Woodnick described medical information he received regarding Miss Owens. Since the status conference, respondent has received confirmation from nearly all providers that petitioner was never a patient of theirs. Notably, the HIPAA releases for Dr. McCool revealed that petitioner had never attended an appointment at his office. I mean, that could be considered medical information. All right. Mr. Woodnick's motion also included copies of medical documents exchanged between the parties, including a letter to one of Miss Owens' doctors. Did we see that? I don't think we saw that, though. That was the thing, is it was exactly. It's different than posting a blog. And we didn't get a lot of the exhibits. Let me see if Volo is acting correct for us. Because a lot of times Volo doesn't like to behave with me. All right, let me go here. Because thing is we didn't get a lot. Also, Woodnick never posted his. So it was a motion to compel on March 11th. So let's go to that. All right, March 11th, motion to compel. Let's come over here and look. We're going to share this tab. Okay, so we have Woodnick's motion to compel. And here's his hand-sized fetuses. And you know, Gingras loves this motion. Oh, we did get the exhibits from this. Okay. But the thing is motion. So what I will agree with, this is a one that I think he should get in trouble for the blog and the Twitter. But Woodnick filed him in the court. Woodnick did not file him under seal. So therefore, David Gingras didn't have to. I would agree. Neither one of them were filing things under seal. And Woodnick put in medical information in a filing. So when the bar is saying Gingras should have filed it under seal, and Gingras is saying, well, Woodnick didn't file his shit under seal, and he did the same thing, because he always has to say, well, he did it too. Okay. So I'm oddly going to agree with Gingras on the fact that Woodnick did file things and they weren't under seal. And then we get to these exhibits, like Exhibit 1. Which this was... Okay, so wait. Well, he did describe things in there that she wasn't a patient and stuff like that. This exhibit is Woodnick Law sending a message to the people for their HIPAA releases. That's about the real estate. Exhibit 3. Okay. That is Corey Keith stuff. Corey Keith stuff. This extortion stuff. Exhibit 6. Okay. Talks about Mom, Doc, and Banner Health. Okay. And where she went, but it doesn't have any of her records in here. Like, it doesn't have records, but it does have medical information. But she actually doesn't have any medical information per se, because they didn't get any medical information from the doctors out of this HIPAA form. All they got was, no, she was never a patient. So really, Woodnick doesn't have. I know it's not a sealed case, but the bar is saying that Gingras should have filed his stuff under seal. And so I am going to agree that the bar should not be saying that Gingras needed to file this under seal. But the thing is he's saying, oh, Woodnick shared stuff too. No, Woodnick shared that he didn't get jack squat from any of these doctors she said she went to. I mean, if you want to call that medical information, okay. But there was actually no medical information to be given to Woodnick from any of the places that she said she went. So did Woodnick share medical information or not? Because what we don't have is we did not have the stuff from Mom Doc. We didn't have any of that. Gingras provided us all of those things. The Mom Doc information that we had, the lab report information. He's the one that provided medical records. Woodnick never shared that. We never got any of that information from Woodnick. The only reason we know what was said to doctors and what was on her lab reports is because Gingras put that out there. So I do not agree that Woodnick shared medical information. Did he talk about some medical stuff and that there are no records to be found from those places? Yes. And he did attach a thing that he said, hey, this is a HIPAA form that is signed for names under this. So he is being disingenuous in these things. So it wasn't he did it too. And maybe medical information needs to be defined better. But he actually provided records. Gingras or Woodnick was just like, she lied, she lied, she lied. There is nothing, she lied. That's what that's what Woodnick did. Or he's saying when he talked about the hand-sized fetuses or the fetuses, that was sharing medical information. He didn't put it under seal. So, okay. But if we take out just the filings, if we take out what they did in the filings, and let's say it was okay with putting it in a filing and submitting it to the court. Great. But you still have, because we're going to say, okay, the court filings are sharing it between the parties. Even though public can get access, it's sharing it between the parties. Let's say that, okay? But when you put it on your law blog site and you put it on Twitter, that is no longer sharing it between the parties. So while throw out that it wasn't filed under seal shit that Jim said, okay? But he should get in trouble for the Twitter and the blog posting. I think that would be fair. Like I said, I'm going to call things the way I see them, which sometimes means that Gingras, it's not the way Gingras says it is, but it's understanding kind of where he's going and where he's coming from. And that's right. You cannot be late if you do not menstruate. That was, I love it, Henrietta. Love it. Okay. Now let's get back to this stupid thing. All right. So, yeah, when he says status convert responded has received confirmation from nearly all providers, petitioner was never a patient of theirs. Notably, the HIPAA releases for Dr. McCool revealed that petitioner had never attended the appointment. That's not medical information because she was never a patient, which means they have no medical information on her. So I'm not agreeing with you there. Wooding's motion also included copies of medical documents exchanged between parties, including a letter to one of Miss Owens' doctors. Okay, that was a letter to her doctor. That was not medical information that was private. No, but he's saying that letter about the HIPAA form clearly constitutes medical or other documentation disclosed, and that Winnick didn't file that under seal. The unsealed motion also included other private medical information disclosed between the parties and Miss Owens. Based on these facts, respondent's position is simple. The bar has simply misconstrued the language in the February 21st order to make it appear the court issued either a protective order or an order requiring information to be filed under seal. In truth, the court did no such thing. It did not issue a protective order nor a sealing order. It in fact denied all such requests, not once, not twice, but 3 times in a row. It just needed to be shared between the parties. That was it. And you didn't do that when you put it on your blog and Twitter. You shared it to other people, not the parties. So I don't think it's the same. I get what you're trying to say. It's just not the same. Woodnick's post February 21st conduct confirms this view. It shows he understood, just as respondent did, there was no requirement for medical information to be filed under seal, contrary to the bar's claims. This also shows even if the state's bar interpretation of a minute entry was correct, it is arbitrary and unlawful chosen to pursue discipline against respondent, but not Mr. Woodnick. Once again, Woodnick didn't share any documents that he got. He made a summary statement that there was nothing to be got. And you're the one that shared the documents and the labs and the reports from all these places. But like I said, take away the pleadings and just the bar could just focus narrowly on posting it on his blog and posting it to Twitter. Was that a violation? But if they're going to say that the pleadings were a violation, I mean, they can do what they want with that. Maybe they're going to be like, you know what? Fuck this one. This is the least repulsive thing that you did. This actually made your client look 10 times worse, but you know, this is where you were not representing her very well. In context of Rule 12C motion, this court must accept respondent's allegation as true, and it must construe all inferences in respondent's favor based on the standard. Material facts are clearly in dispute concerning the exact scope of the meaning of the vague order respondent allegedly violated. Those factual disputes preclude resolving the bar's motion on the pleadings. So, let's see here. Go back up to where he has the ruling. Medical or other documents, exhibits, medical records, etc. I mean, I agree it is kind of vague. Okay. The bar's position is legally incorrect. Even if the facts were not disputed, the bar's position in the court issued a valid sealing order, which respondent violated, is legally incorrect for two reasons. Multiple requests. Um, let's see. The bar's argument fails as a matter of law. This is also because the due process clause prohibits enforcement of vague or ambiguous court orders, even by contempt or otherwise. Any order that fails that test is simply not enforceable. Judicial contempt power is potent weapon when it is when it's founded upon a decree too vague to be understood. It can be a deadly one. The order, though, it I don't think it was too vague for you to realize that you can't just be posting it places. I just don't see how anybody's gonna agree that you could post it the places that you did. And whether you should be allowed to or not, I that and they may still consider it too vague and just not do anything with this and dismiss this one without punishment, but I guess we'll see. Because the specificity required derives from federal due process. Here, respondent asserts even if the single sentence quoted by the bar, which does not contain the word orders or seal, appears clear when read in isolation, when viewed in the light of other facts, like the fact the court repeatedly denied all of other requests if made confidentially, it's too ambiguous to satisfy the due process requirements. Okay. I think we've explained this. Let's see. Here, the trial court member made the findings. Owens was extremely high profile. As the case was pending, Mr. Woodnick aggressively published statements attacking Miss Owens in a press release. Actually, Clayton released that, not Woodnick. Unless it was on Woodnick's letterhead. I don't remember if it was or not. Considering Woodnick's choice to file unsealed pleadings with Miss Owens' medical information, respondents simply followed the same practice by releasing Miss Owens' own medical records to explain her side of the story. But yet, her medical records don't explain her side of the story. Yeah, no, he's playing like he's stupid. He shouldn't have been sharing it. This is why we told Laura, your lawyer does not have your best interest at heart. So he's like, well, Woodnick's sharing things. Woodnick didn't share medical records. You shared medical records. In that situation, any order purporting to prohibit Miss Owens from using her own medical records to respond to public allegations made by Mr. Woodnick would have been unconstitutional, just as Mr. Woodnick successfully argued in opposing Miss Owens' request for confidentiality. The thing is your client wanted it all to be confidential. So it's really crazy that she was like, "Yeah, release all my medical stuff." When she's the one that no, what she wanted was Clayton not to be able to share his side of the story so that she would quit looking bad. She wants to still be able to tell her story and put out her stuff, but the thing is Her medical records don't explain her side of the story. They just don't. Let's see. Constitutes an impermissible prior restraint on protected speech. Well, your client's the one who kept asking for that restraint. And you want everybody's speech to be restrained unless it agrees with you or your client. But it is not uncommon that medical records do not get shared. Facts of the case can get shared, but specifics on medical documents and stuff like that, they don't get shared. So nothing should ever be sealed, I guess, is Gingras's response to this. People should be able to share their medical records, and maybe they should. Maybe clients should be able to share their own medical records. But she was saying that Clayton couldn't share it. So Clayton didn't share her medical records. And then the respondent answer rises other valid defenses. The above issues aside, the bar's motion also fails because the existence of a viable defense required the court to deny the bar's motion. This response will simply address one such defense, the anti-slap. Which protects the First Amendment, prohibiting any and all state agencies, including the state bar, from unlawfully or unfairly punishing protected speech and petitioning activities. In any legal action that involves a person's lawful exercise of the right of petition or right of free speech, pursuant to the U.S. Constitution and Arizona Constitution, the person other than a state actor or an intervener may file a motion to dismiss or quash the action under this section. The law defines legal action to include any written investigative demand or other compulsory legal process or any regulatory administrative action by state actor. This clearly includes the state bar. When a proceeding is brought seeking to punish a person's exercising of First Amendment rights, the affected person can move to dismiss if the moving party shows the legal action was substantially motivated by a desire to deter, retaliate against, or prevent the lawful exercise of a constitutional right. The court is required to dismiss the action unless the responding party shows that the legal action on the motion is justified by clear established law and that the responding party did not act in order to deter, prevent, or to retaliate against the moving party's exercise of constitutional rights. When respondent moves to dismiss under this section, as he intends to do, to avoid dismissal, the bar will need to show, inter alia, that its claims are justified by clearly established law, and furthermore, that it has a consistent practice of pursuing similar legal actions against similarly situated persons who did not lawfully exercise constitutional rights. I'm sure nobody's out. I'm not going to say nobody. I am pretty sure that there is not a whole lot of people out there doing the shit that you do. And if there is, remove them from the bench, or not the bench. Remove them from the bar as well. Take their license away if anybody else is acting like Gingras. Although this issue is not yet ripe for decision, respondent's answer clearly invokes the protection of the anti-slap. And it alleges the bar is selectively seeking discipline against respondent in a manner which arbitrarily violates the state's bar's own policies, arbitrarily ignoring misconduct by others involved in the same manner. The statement refers to the fact that Mr. Woodnick appears to have violated the same court order in the same manner. Okay. The state bar is not entitled to a judgment on its second claim, accusing respondent of making disparaging comments. While rushing to impose punishment for what it deems disparaging comments respondent made about Judge Mata, the state bar never explains the controlling legal standard for this claim. It is clear why, because the bar's position is directly contrary to law. In short, when lawyers are engaged in public speech on public issues, how do I make this bigger? Yeah, I think it might have been on that. So, but once again, Woodnick did not share medical records. He just said she lied. He never shared any medical records because there was no medical records to receive. So, all right, let me zoom in on this because this is. In short, when lawyers are engaged in public speech on public issues, at least outside a courtroom, they have the same First Amendment rights as everybody else. On that much. The United States Supreme Court has spoken loud and clear. At the very least, our case recognizes that disciplinary rules governing the legal profession cannot punish active protected by the First Amendment speech. And the First Amendment protection survives even when the attorney violates a disciplinary rule he swore to obey when admitted to practice law. Hmm. I'm gonna have to go look at these sites because I know usually they don't say what he means that they say. You're allowed to say you don't like Judge Mata's ruling and you disagree with it. You are allowed to do that. You are not allowed to accuse her of crimes that she didn't commit. Although the Arizona Supreme Court has not published any decisions directly on the specific issue in the last 25 years, multiple courts around the country have done so. The rules established by those cases are clear. A lawyer who criticizes a judge cannot be punished unless the lawyer's statements were factually false. We begin with the accepted legal principle that if an attorney activity or speech is protected by the First Amendment, disciplinary rules governing the legal profession cannot punish the attorney's conduct. Maybe they just can't go to jail for it. And then he cites case saying, agreeing attorneys who make comments impugning the integrity of a judge are, however, entitled to other First Amendment protections applicable in defamation contexts. To begin with, attorneys may be sanctioned for impugning the integrity of the judge or the court, only if their statements are false. Truth is an absolute defense, but you don't have any truth to what you say. You have tinfoil hat conspiracy theories. Explaining the First Amendment does not protect intentional false statements and false statements made with reckless disregard for the truth. Truth is absolute defense to any statement made by an attorney that impugns on the honesty or integrity of a judge. In its motion, the state bar never discusses the critical issue of the law. Instead, the bar cites authority, some of which is clearly no longer valid, as support for the requested relief. On inspection, none of these cases help the bar either. So, in the matter of James Lawrence Riley, which is a case I was trying to look up a while ago, from 1984, is a 42-year-old case involving a lawyer campaigning to become a judge. During his campaign, the lawyer made statements criticizing his opponent, an incumbent judge. The Supreme Court found those comments violated a special rule, DR 8-103, applicable to judicial candidates. This rule has no application here because respondent is not a candidate for judicial office. Okay. In a passing comment in Riley, the court noted, even if not a candidate for judicial office, a lawyer is held to a narrower standard of free speech than a non-lawyer when discussing the judiciary. That aspect of Riley, for which the court cited a Missouri case from 1957, is clearly no longer valid law. In the light of a more recent U.S. Supreme Court precedent, such as Gentile versus State Bar of Nevada. Indeed, the dissenting Chief Justice in Riley observed as much. Under the freedom guarantee by the Constitution, we must begin with the proposition that, like other citizens, attorneys are entitled to the full protection of the First Amendment, even as participants in the administration of justice. As noted above, this more modern view has been fully adopted by the U.S. Supreme Court, and substantially every state and the federal court has considered similar issues. Then that should mean that nobody should ever be able to be fired for anything that they say. Like that just is not the case. Because somebody coming into work and tells everybody to fuck off. They're using their First Amendment right to tell everybody to fuck off, right? If they're not allowed to be fired for saying that, there would be so many people that wouldn't be allowed to be fired. And that's just not the rule. You could have consequences. You just aren't going to go to jail for it. The bar also cites matters of Ziman. That case involved a multitude of misconduct unrelated to lawyer's speech. In addition, the lawyer engaged in ex parte communication with an arbitrator, argued with him about his rulings, and made a profane and insulting remark to the arbitrator. Ziman has no relevance here. Respondent is not accused of making any profane or insulting remarks directly to a judge. Rather, the allegation is that respondent made certain disparaging public statements about a judge, which the bar has not shown were factually false. You haven't shown they're factually true. Footnote 2 says, respondent fully agrees that when a lawyer is standing in court directly addressing a judge, jury, or witness, the First Amendment may offer less protection than it does outside of the court. An attorney is not free to say literally anything and everything imaginable in a courtroom under the pretext of protecting his client's rights. But I think you are not allowed to do it when you're acting as an attorney. And you're acting as an attorney in your filings and on your law blog website. You're acting as an attorney. They say in Douglas B. Levy was a case involving private, not public statements made by a lawyer to opposing counsel. Although the lawyer also made comments criticizing a judge, the respondent never claimed his comments were true. And he apparently chose not to invoke his rights under the First Amendment. That case never mentions the First Amendment. The case also does not mention Arizona's anti-SLAPP law, which did not exist in its current form at the time. I'm just not thinking that. Vladimir Gagic involved a variety of bizarre attorney misconduct. Unlike this case, the attorney in Gagic did not properly invoke First Amendment and did not raise any factual/legal defenses in his response to the motion for summary judgment. Respondent does not controvert any position of the State Bar's statement of facts, discuss the ethical rules at issue, or cite relevant legal authority. Because Gagic waived his defenses by failing to assert them, the case contains no analysis of the First Amendment. Gagic is of no help to the bar's position. So they're all different because none of them said First Amendment, but Gingras did. Okay. I feel like I've gone over Gentile before because I think Gingras brings up this case a lot. Hmm. All right, okay, here's Gentile. All right. Just based on Copilot. So take it for what it's worth. Do your own research. I'm just gonna, yeah, they're professional standards. And I think that's just what he's not getting. So Gentile was a criminal defense attorney and he held a press conference after his client was indicted on criminal charges. And during the press conference, Gentile made statements asserting his client's innocence and alleging misconduct by law enforcement, which I believe Karen Reed and them did as well. Following the acquittal of his client, the State Bar of Nevada filed a complaint against Gentile. Okay, so Gentile's client was acquitted, kind of like Karen Reed. All right. Yeah, he does seem to be better at home improvement and laying tile than being a lawyer. Maybe that's why he likes Gentile, the case, and claims that the statements violated Nevada Supreme Court rule, which restricted attorneys from making extrajudicial statements that could materially prejudice at trial. Okay, if that is what Gentile is about, is that this guy made statements that could materially prejudice at trial, that is different than this because, yeah, that's why there was a gag order put on the attorneys in the Reed case, is because it could tamper the jury. The legal issues raise significant questions regarding the First Amendment rights of attorneys and the extent to which their speech can be limited in context of ongoing legal proceedings. The Nevada Supreme Court upheld the disciplinary action against Gentile, leading to an appeal at the U.S. Supreme Court. So the bar was like, no, you're going to be disciplined. And the Supreme Court's decision in 91 said that Nevada's Rule 177 was void for vagueness. The court held that the rule failed to provide clear guidance on what constituted permissible speech for attorneys, particularly regarding the terms general and elaboration. With lacked settled legal definitions, the court emphasized that any limitations on attorneys' speech must provide clear notice to those affected. The ruling underscores the importance of balancing the rights of the attorneys to speak freely about their cases with the need to ensure fair trials. While the court acknowledged that some restrictions on attorney speech are permissible, it emphasizes that such restrictions must be clearly defined to avoid arbitrary enforcement. This case has had lasting implications for the legal profession, influencing how attorney speech is regulated and ensuring that attorneys are aware of their rights and responsibilities when discussing ongoing cases with the media. And that was a Nevada case. And so maybe this is going to be the case for Arizona to put something in there. Yeah, I don't know. Gingras is good at drinking. Okay. That's what we know. But you know what? He's not even as good as his friend at drinking because his friend was having a grand old time and Gingras was not having the grand old time. So maybe Gingras doesn't even drink properly. Like, what does he do correctly? Nothing. Okay. Let's go back to this stupid motion. Okay. Material facts are disputed. With respect to the bar's claim that respondent must be punished for the statements criticizing Judge Mata, the position must be rejected for one simple reason, because respondent has never admitted that any of his statements were false. On the contrary, the amended complaint alleges respondent violated multiple rules by making public statements about Judge Mata's qualifications or integrity that were objectively false, or made with reckless disregard as to their truth or falsity. Yeah, because you don't care if they're true or false. You're making those recklessly because you don't know anything. You're just out here spewing shit off. That you have nothing, you have no proof to show what you were saying. Any reasonable person would have come to the same conclusion because nobody else comes to that conclusion. That there's a conspiracy against Laura and you. Respondent's answer flatly denies this allegation in its entirety, not merely conditionally, as the bar claims. As noted in the extensive legal authority cited above, the lawyer's criticism of a judge cannot be punished absent clear and convincing proof the lawyer's statements were false, and the lawyer either knew statements were false or the lawyer acted with reckless disregard for the truth at the time the false statement was made. In this context, reckless disregard is a term of art. Reckless disregard means that a statement is unprotected if the speaker made it with a high degree of awareness of probability or probable falsity. And I believe that existed. You knew that what you were saying was probably false or entertained serious doubt as to the truth of his publication. You knew that what you were not, you knew what you were saying wasn't true. You just don't care because you will just go out there and say shit. There were better ways to go about saying that you disagree with her, but you have accused her of crimes. You've accused her dad, her sister. So Judge Mata's dad, Judge Mata's sister, and Judge Mata, you have put in this conspiracy that all this stuff, you've accused them of crimes. You knew there were high degree of falsity and that there were serious doubts as to what you were putting out there. Here, the complaint alleges respondent made false statements and acted with reckless disregard for the truth without any well-pleaded factual support for those claims. In his answer, respondent unequivocally denied that allegation and further raised First Amendment as a defense. In this posture, the material facts: was respondent's speech false? And if it was, did respondent act with reckless disregard? Are disputed. As such, judgment on the pleadings cannot be granted. I believe they were false. And you knew them to be false because you had no proof that they were true. Respondent answer raises valid defenses. No, I don't think you did, but okay. Let's see. Because the state bar appears to misunderstand this issue, respondent will make this extremely clear. Oh, aren't you so helpful, Gingras? If a lawyer makes a statement which is factually true, it is irrelevant whether the lawyer acted with reckless disregard. A true statement can not be made with reckless disregard for the truth. Put it differently, true statements may never be punished. Only intentionally false statements and false statements made with reckless disregard for the truth. Yeah, well, you did that. So, conclusions. Nobody should judge on the pleadings. All the best, Gingras. Oh my God. And it's so condescending because he acts like he's the smartest person in the room. And he's not, but okay. So we read that one. We read that one. All right. We've been going for a bit. How long is this? All right. We'll go over Gingras's declaration real quick because we can kind of skim through it just because some of it just doesn't matter. Like that he's over the age of 18 and all that. Okay. So we know Gingras is over the age of 18. And he is a U.S. citizen, that he was, he's practiced in certain areas. He has a license to practice in California and Arizona since certain dates. The origin of the dispute is a family case, Owens v. Eckerd. He says it's complicated. That Owens v. Eckerd began with a petition filed by Owens on August 1st, 2023. She accused Eckerd of a sexual encounter and that she became pregnant as a result. And Eckerd denies that and says she fabricated the pregnancy. He did not file the petition in that case. And he had no involvement until March 25th, 2024. Everything else before that date was before his time, and nothing there is his fault. He talks about things that happened before he appeared. Mr. Owens explained the respondent, Mr. Eckerd, was a celebrity who appeared on The Bachelor because she always has to mention that. Owens expressed concern that due to Eckerd's celebrity status, media outlets, New York Post and Page Six, have expressed interest. Yeah. But you know why they expressed interest? Because she contacted them. Oh, she was fearing this publicity. Is that why she went to them? See, this right here is disingenuous. She didn't fear the publicity. She's the one who started the publicity. Disingenuous and lying. And then they talk about that Owens wanted the case sealed. so that the general public may not access it. Yeah. Because she didn't like that the truth was coming out and it wasn't on her side. She would have loved the publicity if they were on her side. Let's see. Motion noted Rule 17C1, the Rules of Family Law Procedure, allowed courts to seal their records if there exists an overriding interest that overcomes the right of public access to the record. Ms. Owens then asserted that due to sensitivity but sensational nature of the case, public disclosure serves neither the best interest of the parties nor public access to judicial records. According to my review of the docket, Mr. Eckerd never responded to or opposed Ms. Owens' motion to seal. Despite that, the court denied it. The interim, Owens and Eckerd made an agreement to submit samples for genetic testing. According to Ms. Owens, the result of that testing was inconclusive. It was going to always be inconclusive because there was no fetal DNA to make a conclusive finding because there were no babies. Owens claimed that she visited an OBGYN facility called MomDoc in November 14th, 2023, where she received 2 pregnancy tests. Both were negative. They did two pregnancy tests? Okay. After learning she was no longer pregnant or was not or no longer pregnant, Owens filed nothing further in the case. Due to inactivity on December 4th, 2023, the court issued an order placing the case on the dismissal calendar. And then Clayton said, not so fast, because he wanted to avoid the dismissal of the case, and included an affidavit of non-paternity, a motion for leave to amend Mr. Eckerd's response to the paternity petition, and a motion to extend dismissal date and schedule an evidentiary hearing. In these pleadings, Mr. Woodnick accused Ms. Owens of fabricating pregnancy. He asked the court to declare Mr. Eckerd was not the father of any unborn children, even though by this point Ms. Owens was no longer making that claim. Not at that point, but she was saying she had these, but she can't even prove she was pregnant. And you have to prove you were pregnant in order to prove that there were any babies to father. After Mr. Eckerd retained counsel, Owens did the same and got Alexis Linvall as her attorney. Linvall filed the motion to dismiss with prejudice, stating that there is no paternity or maternity to establish because she's no longer pregnant. Despite Ms. Owens' effort to dismiss the case with prejudice, on January 3rd, Woodnick filed the motion for sanctions. The family court equivalent to Civil Procedure Rule 11. Yeah, but the sanctions weren't just for Rule 26. It is undisputed that the prior filing of Rule 26 motion failed to comply with the safe harbor, blah, 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 blah. Okay, we're going past Rule 26 because we know his argument. After Woodnick moved for sanctions, Owens' original attorney withdrew. Corey Keith appeared. Immediately after appearing on the case, Owens' new counsel, Keith, filed a motion for confidentiality and preliminary protective order. That motion invoked Family Law 53A, and it asked the trial court to issue a protective order which would provide relevant discoverable information which either party designated as confidential remains confidential and is not disseminated to anyone other than the parties and their respective counsel. On January 19th, Woodnick filed the pleadings, angrily objecting. As if you weren't angry ever filing shit. Okay. Petitioner requested further relief, impermissible prior restraint of speech. Beyond that, it also represents tremendous overreach. Let's see. Apparently, petitioner feels she is entitled to what is essentially a backdoor motion to seal after the court already denied. The court must begin with the presumption that a prior restraint on protected speech is dubious and subjected to highest scrutiny. Petitioner does not address or even attempt to explain why prohibiting respondent from speaking about the issues she brought in this action would withstand constitutional scrutiny. She's the one that asked for the shit. Petitioner demand would trigger a woefully unnecessary and inappropriate procedure, overtly designated to thwart disclosure. The fact that discovery may annoy or embarrass petitioner does not mean that sealing and confidentiality are appropriate remedies. Agree. Not only is respondent entitled to the information and discovery necessary to defend against her claims, but he is also has a fundamental constitutional right to discuss the nature of those claims, just like any other litigant. Petitioner is requesting an order would prohibit respondent from defending his character in public view, despite the fact that she made his character a matter of public interest and that she self-identifies as a public figure. Toothpaste cannot be put back into tube. It is premature to designate as confidential documents, recordings, or records that do not exist and have not yet been produced. To the extent a response to this assertion is warranted, there is nothing to be designated confidential. Yeah, at that time, they didn't have anything because she hadn't signed a HIPAA form. Yeah, she fears bad publicity. That exactly. She's okay with good publicity, just not bad. Yeah, she need when she's marketing herself. And this wasn't good for her marketing. Based on these angry, empathetic assertions, Mr. Woodnick's motion concluded with a demand for the court deny the motion for confidentiality. I'm glad he's like Woodnick angrily, as if Gingras doesn't have an attitude. On February 15th, the trial court adopted Woodnick's arguments and denied it in its entirety. Ms. Owens requested for confidentiality or a protective order. A short time later, a hearing was held on February 21st. At that hearing, Ms. Owens' attorney Keith made a verbal motion asking the court to reconsider its denial of Ms. Owens' request for confidentiality. On the record, the court denied that request, again, in its entirety. It is further ordered denying counsel for petitioner oral motion to reconsider regarding the ruling concerning petitioner's motion for confidentiality. After the court refused to grant any relief for the third time, it appears Woodnick and Mr. Keith reached some sort of informal agreement regarding the sharing of medical records. I was not present at this hearing, was not privy to the discussions between counsel, did not represent her. Yeah, before my time, no nothing. My understanding is that based on the informal agreement between Mr. Keith and Woodnick, the court issued an observational note, not an order, which stated, let the record further reflect. Well, when a judge puts that no party shall disclose outside of themselves any medical or other documentation, exhibits, medical records, etc., I think that's what she means. Several critically important events happened next. March 11th, Woodnick filed a motion to compel. Woodnick made the following representations to the court. Yeah, but he didn't share medical documents, medical records. He just said, hey, this is some things. Mr. Woodnick further represented to the court petitioner has willfully and wantonly failed to disclose information pursuant to Rule 49. Petitioner provided minimal disclosure after evading any compliance with Rule 49 for 8 months. Based on those representations, Mr. Woodnick asked the court to order Ms. Owens to produce 5 different categories of documents, including the California paternity file from 2014, where she was first accused of faking pregnancy. As it turns out, all of Mr. Woodnick's representations to the court were knowingly false. No, they were not. Ms. Owens made none of the statements Mr. Woodnick cited from her deposition. He didn't quote them verbatim. He didn't quote them verbatim, just that she miscarried. So, Miss Owens made none of the statements. Mr. Woodnick lied to the court, claiming that Owens had failed to provide information required for over 8 months. In reality, Miss Owens fully complied with all Rule 49 disclosures obligations at the time. No, she hadn't, because they would have information about the supposed LA Planned Parenthood if she had. But if you want to say that there was nothing for Laura to hand over because there were no medical records proving there was nothing for her to get, nothing for anybody to get because she didn't go anywhere, that would have been one thing. But she said she went to these places or she had appointments there. She went to Planned Parenthood in San Bernardino or Mission Viejo. And then on the stand, she said she went to LA. So, yeah, she would have not been compliant with the Rule 49 disclosure. But because there was nothing to be disclosed because she lied, then I guess maybe she didn't violate the disclosure. What is this? Wonder where the board would meet on quarterly basis to review the company's situations. Could it be the dining room table? Let's see. Back mine by somebody marketing themselves and learn the difference between gross profit and net profit. Yeah. Yeah, and knowing the difference between a CEO and a manager would be very important if you're gonna be an entrepreneur. You should know where your documents are that define your percentage in the interest of the LLC, yes. And you should know where the tax filings are for that company. Hey, Pancake House is good. I love me some pancakes. So, yeah, I guess she fully complied because there was nothing to get because she's a liar. If you wanna do that technicality. But even though they knew she lied, she kept saying she had been to these places. So she needed to hand over everything from these places she supposedly went to. Um, on March 25th, 2024, Mr. Woodnick filed a motion for relief from the judgment based on fraud in relation to order of protection case assigned to a different judge. Mr. Woodnick accused Owens of committing fraud in order to, yeah, that's why she's being charged, because she did commit fraud in that hearing. To support that request, Woodnick attaches pages from Owens' deposition transcript and medical documents, including a sonogram exchanged between the parties. Mr. Woodnick filed his pleading under seal in the OOP case and then moved for a joint hearing in the paternity case. In addition, the filing unsealed publicly accessible pleadings contained medical information, but they did not contain any medical documentation. A copy of the press release. The press release contained details discussing medical information, but there was no medical records shared. But it does say, yeah, because there was nothing of Laura's that was shared in those documents. Everything that was shared was Clayton's. It was the law offices. It was work product. It had nothing to do with that. Let's see. I first came on the case. Quickly determined it was impossible to address the issues in the motion to compel without client's file. Wouldn't refuse to give me an extension. Court denied my extension. He wanted to go to lunch because client was refusing to speak with me by telephone because he doesn't have to speak to you by phone. You can speak by email. You love typing so much. Why do you want to be on the phone? Let's see. I filed entitled response, amended the motion for relief based on fraud, attached med chill and all that, disclosed his expert witness's report. Wouldn't disclose his expert witness report to me. He did not mark it as confidential, nor did he ever ask me to keep it confidential. Notice he didn't share it with anybody. He shared it with you. He shared it between the parties, which is not what you did. Based on my review of Mr. Eckerd's expert witness, I saw nothing confidential in it. I am extremely familiar with legal standards controlling when, where, how a party may request to leave to file a document under seal. At the time, I was aware that Ms. Owens filed a second motion asking the court to issue a protective order, blah, 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 and it was denied. The expert reports I filed with the court were submitted in a response to a claim that Ms. Owens committed fraud. I believe both reports were helpful to refute the allegations based on the information to me at the time. They don't refute anything. Of course, because Mr. Woodnick did not file his motion under seal, because the trial court had repeatedly denied all this shit, I didn't file mine under seal. Okay. As a lawyer of 25 years, he's always got to say that. I have been involved in numerous cases where protective orders have been issued. In every single instance, those protective orders have been crystal clear, leaving no doubt. Refused to speak to me on... I was not present at the time the agreement was made, and unfortunately, Mr. Keith was less helpful than when I contacted him to discuss the case. Also, because Mr. Woodnick refused to speak with me by phone, my ability to seek clarification on the meaning of the court's comment was severely limited. He emailed you about the shit. You could have emailed back. Didn't have to be on the phone. Nothing says they have to talk on the phone with you. Yes, please hit that. It's free and support me. Let's say she did think she was pregnant and did think she miscarried. Wouldn't you just say, hey, I don't have any good proof of pregnancy or paternity, so I'll pay all the bills? No, I don't think so. Because she should have been able to, from May 20th to November, she still should have been able to prove that she actually was pregnant. And I think it would have just been like, okay, like we can't prove paternity and there is no baby, but if she just it didn't doctor anything, I think it would have just been like, okay, everybody just pay their attorney's fees and go on. Like none of this shit had to happen. It was her arts and crafts and lying and omitting things that got her here. Because it really would have just been like there would have been nothing to sanction had she not done all the extra shit. Let's see. I'm aware the state bar has charged me with the misconduct for making public statements about Judge Motta's qualifications and integrity that were objectively false or made with disregard. I absolutely deny any statements I have made regarding Judge Motta were false. On the contrary, I firmly believe every statement I've made about her is either 100% factually true or constitute protected expression of opinion based on fully disclosed facts. You don't have anything proving what you said is true. Every statement I made in July 8th affidavit was true and correct to the best of my knowledge at the time I filed. I reviewed this affidavit again today, and everything I said remains true and correct to the best of my knowledge, with the only exception being where I said that I had published a small number of comments, approximately 15 posts, regarding the Owens case. While that number was correct at the time, since I have had posted numerous additional times about this case, as have many others. I was talking about First Amendment. As no point did I make any statement with actual malice, reckless disregard for the truth. On the contrary, every statement about Judge Mata was either factually true or was made with reasonable basis formed. No, there was no reasonable basis to think what you were thinking. That specific statement was made after multiple different people posted videos on YouTube claiming they personally attended the trial. They talked to Mr. Howe, and he told them he had, in fact, been discussing the case with his daughter. Yeah, but you call us all liars, but you're going to believe us about that. So, are we liars or are we not liars? And then he submits his little video we've gone over in the past. For that reason, I first learned that there were people claiming I did not rush to accuse Judge Mata of any misconduct. Instead, I did the only thing I felt was reasonable under their circumstances. I sent an email to Judge Mata's division informing the court of concerns and asking the judge to respond to several questions. Ex parte, a true and correct copy of this email is attached. I took the unusual step of emailing Judge Mata to ensure that I did not make any statement about her integrity without first exercising reasonable diligence to verify. But you didn't get any verification. So that doesn't mean that because you did not hear back from her tonight, that you can just go and say things. Because she didn't respond, that means it's true. No. Instead of responding to my questions, she issued a ruling in a case she was presiding over. In my opinion and disbelief, that after I sent the email, was worried to disqualify her from the case based on an issue of her discussing the matter with her father. Based on that concern, I believe Judge Mata rushed to issue her decision. No, it was real easy to issue this decision because Laura is clearly a lying liar who lies. She needs Jesus. So do you. I found that the level of basic error too extremely suspicious because prior to trial, I provided the court with lengthy and detailed proposed findings of fact and conclusions of law. Yeah, nobody agrees with you though. For these reasons, among many, many, many others, I believe every statement I have published about Judge Mata was either entirely true. No, you didn't. Okay, that's his statement. And it's just, and here's the press release. Yeah, once again, it does not have any medical documentation or medical records and any of that shit. I think if she wouldn't have done all that. And the thing is it, it would have been one of those things that was like, sorry you got sued, but you're going to have to pay for it. But her arts and crafts started before she filed this case. And he found, well, maybe not, but he found out as before he had a lawyer that this case, she was doing arts and crafts and stealing things. And so I think if she really was pregnant and and there was no stealing or anything, like, this wouldn't be a thing because she would have been really pregnant, and Clayton would have just had to probably pay his part, but there wouldn't have been all this back and forth. It would have just been a simple thing. I think that Clayton would still have to pay his bill. It sucks that the bill should be put on her anyways, but that's usually not how things sadly work. There's a lot of time, especially in family court, there is times when they're like, they the the wife or the dad will bring frivolous motions and stuff, and the attorney is like, "I would like the attorney's fees for this stupid meeting that we had to have because this was frivolous or it was a lie." And judges are usually like, "No, right now everybody's just gonna cover their case." I agree that Clayton shouldn't have to pay the bill if you bring stuff like that. It sucks, but they're not going to they would think that if they made her pay Clayton's bills, they would probably think in their mind that, "Oh, because I had a miscarriage, now I have to pay this person's bills because that's not fair either." If she was actually pregnant and she miscarried before paternity could have been shown. Right. No, I agree. What's ethically right for her to do in the situation, but it would suck if, let's say, I was pregnant and I took Bruce to court. A duck and a moose walked into court, okay? And I was pregnant and I was wanting to get paternity time. I was wanting to establish child support and when all that would start. I would want to prove that the moose was actually the father of this duck's child, okay? But during the duck and the moose's court and trying to prove the pregnancy and all that, the duck had a miscarriage and lost Moose's baby. Well, she didn't prove she had a miscarriage. That's true. But so if you're saying I had a miscarriage and I couldn't prove I had a miscarriage, but if she was actually pregnant, yeah, I just think if you're actually factually pregnant and you actually factually miscarried because but you're gonna have see, there's no way that you can factually be pregnant and factually miscarry and not be able to prove it. There's no way. It just because there's either a baby or there's not. And if you knew that you were pregnant and you can prove that you were pregnant, and then at one point I didn't prove I was pregnant and I didn't prove I had a miscarriage. Well, this duck would have been walking up in there showing I don't know what I would have been doing. I just don't think that's the thing is you're asking for something that I don't think is even a thing, because I don't think there's people that go into court and and say they're pregnant and say they miscarried and don't prove any of it. In that case, no, Clayton should not have to pay the bill. But if I just walk into court, if the duck just walks into court and says, "I am pregnant with Moose's baby," no, I peed on a stick, okay? I peed on a stick. But it doesn't say, "Yes, it's moose DNA" on the pee stick, you know, that and then later I say, "I miscarried." No, Clayton should not have to pay those bills. Laura should have to pay those bills because it wasn't proven. And I should have to pay the bill too. If I'm like, "Yes, I'm pregnant. Here's an HCG test, and, also I miscarried, but I was in the middle of the ocean, and so, like, the water, like, got rid of all the evidence of my miscarriage as a duck, and I didn't there was nobody around us in the ocean to take pictures of me having this miscarriage, so but yeah, that's what happened. Yeah, so Laura did not prove pregnancy, paternity, or miscarriage. She didn't, and for all those reasons, Clayton should not have to pay his attorney's fees. I agree with that, Bruce. I just don't know if there's people that have done all of this because she is so, like, because people don't do this. Like, most people that go in there, trying to pull off pregnancy scams in court, there is a baby. There is a baby, or there was a baby that was born, or there's been an actual sonogram, and there's proof. I don't know if anybody can find another case where a woman went to court and said she was pregnant with no medical evidence or with nothing. She just said she was pregnant and she miscarried. I would like to know that there really was no pregnancy. If there is another part, I don't think it is, and that's why this case is so unique and crazy because people don't do this. Like, not in a courtroom. Like, people will do pregnancy fake stuff out, you know, to their boyfriends all the time. That's why, like, April Fools, I'm like, "Do not play a pregnancy prank on somebody. Just don't do it." Because people do that all the time. They'll pretend to be pregnant. They're not. I don't think they're doing it in court, and that was the thing about Laura that was so intriguing is this woman went to court with this shit. She wasn't just doing it to the guys. She was bringing it into legal. That's where she fucked up. She could just kept this out of the courtroom and she had just been distasteful and it's still wrong and she's evil for doing all this shit. But the fact that she did this in a courtroom is the problem. They wings and antlers. It would be an interesting combo for sure. But I am not carrying any moose babies. I am not. All right. I think that's where we should end it tonight. We know that Gingras um, served Judge Mata, and I want to look at those. So tomorrow we'll probably look at those. I have a few days that I'm going to be av- available to stream. So probably tomorrow, late afternoon, early evening, I want to go over some other things in the case. Because I need to get caught up on all these documents. Unless a ruling comes out, who knows? But we shall see. Y'all have a great night, day, weekend, whenever you're watching. Love y'all, replay crew. And I will see y'all next time. This is a this is a unique case. For sure. For sure. Mm-mm-mm. All right. See y'all.